Very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S exam prep. So, guys, a very warm welcome to this very important session wherein we are going to disclose a very important information. But before that, in this session today, I'm going to talk about the important legal events that took place in the month of June 2023. So if you are serious about your preparation about CLAT 2024, right, which is going to be happening in the month of December 2023 itself, then this session will give you all the information of what happened in the courts and across the legal sphere. So in this session, we are going to discuss with you some very important details of what happened in the legal sphere in the month of June 2023. But before that, a very important announcement. The second marathon for CLAT 2024 is scheduled on the 29th of July 2023. So it's not very far. So guys, a very important announcement. The mega marathon, okay, this is a mega marathon for 6 hours non-stop. This will be conducted on the 29th of July 2023 starting from 11 a.m. Now there will be 6 hours non-stop marathon, as I told you. So this will be conducted by Abhimanyu sir, Nivedita ma'am, Alpa ma'am, Krishnendu sir, and Ankur sir. So these are the 5 faculties who will be taking this mega marathon, which is scheduled on the 29th of July 2023. So do not miss this. Moving on, let us understand some of the most important things in the legal sphere that took place in the month of June 2023. The first one, in a landmark judgment, the Supreme Court held that judicial review cannot be exercised to reappreciate evidence in departmental inquiry. Now, constitutional courts like the High Court and the Supreme Court, while exercising its judicial review power, cannot decide the case as if it is a case that is coming up in the first instance. Now, trial court, when a case comes before the trial court, the trial judge appreciates the facts, takes on evidence, and decides the matter. But constitutional courts are not empowered like those judges in the trial court are to reappreciate evidence. Now, in a high court, you don't give evidence. In the Supreme Court, you don't stand and give evidence, right? It is all done in the trial court. So the trial court has the power to appreciate evidence and come to a particular conclusion. But high courts and Supreme Court, under the power of judicial review, cannot do it. So constitutional courts, while exercising power of judicial review, cannot decide a case as if it is a first stage of the case. High Court and the Supreme Court cannot reappreciate evidences, which can be done by the lower court. Now, for example, a disciplinary proceeding, a judicial review, especially in a criminal trial, the High Court can send the matter back to the trial court for re-examination, but it cannot re-examine the evidence itself. The High Court has the power, the Supreme Court has the power to send the case back to the trial court, but it cannot reappreciate those evidences in. What did the court say? It is thus settled that the power of judicial review of constitutional courts in evaluation of decision-making process is not the merit of the decision itself. It is to ensure fairness in treatment and not to ensure fairness of conclusion. The courts, tribunal may interfere in the proceeding held against the delinquent, as if it, in a manner inconsistent with the rules of natural justice. Now, if principles of natural justice or certain statutory rules have been violated, the High Court and the Supreme Court can definitely interfere. But it cannot reappreciate evidence because those things have to be done in the trial court itself. So the court said that inconsistent with the rules of natural justice, of course the High Court and the Supreme Court can interfere, or in violation of statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. So in these cases, High Court and Supreme Court can decide. But if the conclusion or finding be such as no reasonable person would have even reached, or where the conclusion upon consideration of evidence reached by the disciplinary authority are perverse or suffer from patent error on the face of the record or based on evidence or not at all, a writ of certiorari could be issued. To sum up, the scope of judicial review cannot be extended to examination of correctness or reasonability of a decision of an authority that matters the fact. Now, on a matter of fact, अगर कोई factual चीज के ऊपर High Court, Supreme Court does not decide, in case principles of natural justice has not been followed, if in case there is violation of statutory rules, or in case the trial court's judgment is perverse, is based on no evidence, only then the High Court and the Supreme Court can interfere in a disciplinary proceeding. But the High Court and the Supreme Court cannot reappreciate evidence. That is the law which has been laid down by the court. The court said the constitutional courts, while exercising its jurisdiction of judicial review under Article 226 or 136, that is special leave to appeal, or to the Supreme Court under 136 of the Constitution, would not interfere with the finding of fact. Now, finding of fact, if there is an error in the fact, it can send it back to the court, into the trial court. But in case there is a perverse judgment, a wrong judgment, only then the High Court and the Supreme Court can interfere. So under Article 226 or 136 of the Constitution, it would not interfere with the finding of fact arrived at in a departmental inquiry proceeding, except in a case of malafide or perversity. That is, where there is no evidence to support a finding, or where a finding is such that no man acting reasonably and with objectivity could have arrived at that finding. And so long as there are some evidence to support the conclusion arrived by the departmental authority, the same has to be sustained. So the power of the High Court and the Supreme Court insofar as fact finding has been discussed by the Supreme Court. Okay, moving on to the next important judgment that came out. Am I clear, all of you? Okay, a judicial review under Pranjali, judicial review under Article 13. I understand. Article 13, no. You file, suppose you have filed a case in the trial court. Now, against the trial court order, you go and appeal before the High Court. It's a criminal case. There are various sections of the CRPC. Under civil law, of course, you can challenge it. Now, if there is no other provision of appeal, then you can also file a writ, okay, 226 or 227, 226 and 227 petition before the High Court. So Article 13 deals with judicial review, I know, but in this case we are not getting into Article 13. Okay, I hope I made myself clear. Next important judgment coming from the Supreme Court. The Supreme Court has said that a will or a general power of attorney, which is called a GPA, cannot recognize a title document conferring right in an immovable property. Now, I'll give you a simple example to make, because these are property laws, so this will be a little confusing at your age. Now, suppose I write a will that after my death, X property will go to A, Y property will go to B, Z property will go to C. Now, does it mean I am the owner of that land? मैं तो कुछ भी लिख सकता हूं, मेरा विल मेरे को ही लिखना है, मैं तो कुछ भी लिख दूं. मैं तो कल विल में लिख दूंगा कि my son will get the Taj Mahal. Does it mean that Taj Mahal belongs to me? Simple. समझ में आया? Whatever is written in the will, whatever you have written in a general power of attorney, does not give conferring right on an immovable property. Is that clear? एक GPA और एक will does not give title of transferring that property to someone else. Very important. Am I clear, all of you? Have I made myself clear? तो अगर आप आपके will में कुछ भी लिख दोगे, आप आपके जनरल ऑफ पावर ऑफ अटॉर्नी में लिख दोगे कि मैं मेरा बेटा को राष्ट्रपति भवन देता हूं, लिख भी दे सकते हो, क्यों नहीं? Does it mean that tomorrow your son will get राष्ट्रपति भवन? Simple. देखिए, whenever you understand the law in the easiest form, that becomes helpful to all. Okay? जितना easily आप समझोगे, ठीक है? तो देखते हैं कि सुप्रीम कोर्ट ने क्या कहा है. The Supreme Court said that in connection with the general power of attorney and the will so executed, the practice, if any, prevalent in any state or the High Court recognizes these documents to be documents of title or documents conferring rights on an immovable property is in violation of statutory law. नहीं, आप will बनाइए, आप जनरल पावर ऑफ अटॉर्नी बनाइए, उसमें कोई पाबंदी नहीं है. You have every right to make your will. You have every right to make a general power of attorney. But that does not confer title on an immovable property. As such, practice or tradition prevalent would not override the specific provision of law which requires execution of a document of title or transfer or its registration. Now, suppose कोई कानून बोलता है कि आप अगर प्रॉपर्टी ट्रांसफर कर रहे हो above the value of ₹100, it has to be registered. Suppose the law of the land, example, it's a true. The law says that if you have to give certain immovable property above ₹100, it has to be registered. आपने will करके क्या वो दे सकते हो आप किसी को? आप क्या जनरल पावर ऑफ अटॉर्नी के साथ वो दे सकते हो किसी को? The court said no, you cannot do it. Am I clear? Have I made myself clear, everyone? Any doubts, any questions in your mind? Any questions in your mind? Let me know. Okay, any questions you have in your mind? Okay, brilliant. So yeah, the court also said that agreement to sell is neither a document of title. Now, agreement, I make an agreement that in the month of August I will sell my property. Does it mean that I have sold my property? No. It is neither a document of title nor a deed of transfer of property by sale. It does not confer an absolute title. An agreement to sell. I agree that in 2025, in the year 2025, I will sell my house to Mr. X. Does it mean that Mr. X has a title over my land? Does it mean that I have transferred my property to Mr. X? No. Agreement to sell means it is in future. It's something in future. Is that clear? So something that can happen in future cannot be said that it is being done today. Very simple. See, law is simple. Don't make it complicated. Okay. Moving on. The next important law that came out from the court. The Supreme Court said that railway will not be liable for theft of passengers' belonging. The court said that we fail to understand as to how the theft could be said to be in any way deficiency of service by railways. If a passenger is not able to protect his own belonging, the railways cannot be held responsible. आप अगर ट्रेन में जा रहे हैं, आपने बैग इधर रखा उधर रखा, बैग चोरी हो गया, railway is not responsible. Now there has been sharp criticism about this particular judgment from various legal luminaries, saying that okay, railway और एयर फ्लाइट में फिर अंतर क्या है? कोई अगर फ्लाइट में जाता है, फ्लाइट का लगेज अगर चोरी हो जाता है, तो द एयरलाइन इज हेल्ड रेस्पॉन्सिबल. आप जेट एयरवेज में जाए, आप एयर इंडिया में जाए, आप किंगफिशर तो अभी तो नहीं है, कहीं पे भी स्पाइस जेट कहीं पे भी चले जाए, अगर आपका सामान खो जाता है तो एयरलाइन इज हेल्ड रेस्पॉन्सिबल. So why not in the case of railways? So there has been criticism, but the law as it stands today, railway will not be held liable for the loss because of theft of certain property that belongs to a passenger. Is that clear? It is the duty of the passenger to protect their own belongings, their own property, and the railways cannot be held liable. Is that clear? Is that clear? Okay. In short, immovable property can make someone the titular. Yeah. Okay. ठीक है? चलो. Before I move ahead, BYJU'S exam prep brings to you a 6-hour non-stop marathon for CLAT 2024. हर एक सब्जेक्ट के ऊपर फैकल्टीज डिस्कस करेंगे क्या चीज आपको पढ़ना चाहिए, क्या चीज आपको पढ़ना नहीं चाहिए. This will be a 6-hour non-stop marathon happening on 29th of July starting at 11 a.m. So guys, get tuned. Do not forget to attend this particular marathon, which is dedicated for students preparing for CLAT 2024. Abhimanyu sir, Nivedita ma'am, Alpa ma'am, Krishnendu sir and Ankyut sir will be there live on 29th of July 2023 starting at 11 a.m. for the 6-hour non-stop mega marathon. BYJU'S exam prep brings to you unlock your 3-day free trial access. So go to the description box below, click on the link and get 3-day free trial access to all our courses. Moving on, the Law Commission has stated certain thing on the sedition law. Now, last year, I'm sure you guys all remember that a 3-judge bench of the Supreme Court, headed by former Chief Justice of India, Justice N.V. Ramana, had put the sedition law in abeyance. उन्होंने बोला था, the Supreme Court said that, from now, no cases, no FIRs will be registered under the colonial 124A of the Indian Penal Code. So the sedition law was kept in abeyance by a 3-judge bench of the Supreme Court last year. The Supreme Court said in its order that we hope and expect that state and central government will restrain from registering any FIR continuing any investigation or taking any coercive measures by invoking section 124A of IPC while the aforesaid provision of law is under consideration. The Supreme Court said that, what is this sedition law? Sedition law, I'll just tell you what is sedition law. Sedition law says that whoever by words, action, sign language, symbol attempts to bring hatred against the government, that is sedition. मैं अगर कल आपको कुछ बोलता हूं against the government और आप गवर्नमेंट के अगेंस्ट सुन के आपके दिल में कुछ खराब लगता है, मैं सेडिशन के अंदर आ जाता हूं. सिंपल. सो इफ आई टेंड टू से समथिंग, now there is something called freedom of speech. Now, can I have a right to criticize the government? Yes, but that can also be a criminal offense under the sedition law 124A. Now, there was a huge debate on it. Now, to give you a brief idea about the sedition law, here is a particular law, or there was a particular law that was brought by the Britishers, a colonial law that was brought by the Britishers to overcome the freedom struggle. So people like Mahatma Gandhi, Bal Gangadhar Tilak, they were all tried under the sedition law. Mahatma Gandhi, Bal Gangadhar Tilak, everyone, all the greatest of the great freedom fighters were all tried under sedition law. Q, because they said that we are not going to cooperate with the government. The moment you say I am not going to cooperate with the government, it is sedition. Tomorrow you raise your voice against the government on any issue. The government might slap 124A. Because sedition means you are creating dissatisfaction in the mind of the people. You are creating dissatisfaction on the mind of the people. Now, so do you have a right to protest against the government? Yes, you have. The Constitution says so. Article 19(1). But here is a criminal law which, criminalizes your raising of voice against the government. So, because of this reason, last year, the 3-judge bench of the Supreme Court held that keep this law in abeyance, no registration of FIR, no continuance of any investigation under 124A. Now, there has been certain recommendation that has been made by the Law Commission of India. And the Law Commission of India, which is headed by Justice Ritu Raj Awasthi, a former Chief Justice of High Court, gave certain recommendation. Number one, it said that FIR for sedition can be filed only after preliminary inquiry and after permission by government. Now, after getting proper permission from the government and after a preliminary inquiry, FIRs under sedition can be filed. Second, provision necessary to safeguard unity and integrity of the nation. So the Law Commission now says that, it is very important that the unity and integrity of the nation has to be protected, and for that 124A has to be kept. Sedition being a colonial law is not a valid ground for its repeal. Now, Justice Ramana, the former Chief Justice of India, in its order said that, it's an old law, it's a colonial law which we got from England, and today England itself has abolished that law. ये जो सेडिशन का कानून है, ये कहां से आया था? इंग्लैंड से. और अभी इंग्लैंड में यही कानून को रद्द किया गया है. So Justice Ramana's opinion was that, the country who gave us sedition law, in that country there is no sedition law today. So why should we keep this sedition law? And this sedition law is opposed to freedom of speech and expression. So, but today we see that the Law Commission of India has recommended keeping this sedition law in the books, but said that, only after preliminary inquiry and permission from government, FIRs can be filed. The Law Commission has also proposed an amendment to the sedition law. What was sedition law earlier? The law was only till here. Sedition law under the old regime said, whosoever by words, spoken or written, sign language, visible representation, otherwise, brings or attempts to bring hatred, contempt, excites attempts, dissatisfaction towards the government established by law. So if you are making any statement, written, spoken, sign language, visible representation, which shows your dissatisfaction towards the government, that is sedition. Now, people have a right to speak. Now, opposition party, whatever they say can be construed as dissatisfaction towards the government. So, can there be a democracy? Now, this was a law that was used by the Britishers to carve down on all these freedom struggle. Now, the Law Commission says that add this part. Okay, what do you have to add? This particular part. Okay, very, very important. This particular part, very, very important. This part. With a tendency to incite violence or cause public disorder shall be punished with imprisonment for life, to which fine may be added, or with imprisonment either description for a term which may extend up to 7 years, to which fine may be added, or without fine. So with the tendency to incite violence. Now, मैं कल बोलता हूं कि I am not satisfied with the government, and then if I say चलो कल हम लोग पार्लियामेंट को तोड़ते हैं, and if people are coming to destroy the parliament, that will be sedition. That is even what the Supreme Court said. Just showing dissatisfaction against the government cannot be sedition. Are those people inciting violence? Because inciting violence is the most important thing. आप कुछ बोलो और उसको अगर एक मॉब क्रिएट होता है और वो इंसाइट करता है वायलेंस, तभी वो सेडिशन होगा. Am I clear to everyone? Okay. But sir, can a police officer refuse to register an FIR about any law just because the court asked not to do, because it is still a law? Yes, if the court, see, every institution in the country has to follow the Supreme Court, and if the Supreme Court has said that do not file any FIR based on section 124A of the IPC, no one should, even if that law is in the books. For example, even today, the Constitution 124 says how judges of the Supreme Court will be elected or will be appointed. Judges of the Supreme Court shall be appointed by the President in consultation with the Chief Justice of India. That is what the Constitution says. But we have a number of judgments on the collegium system. The Constitution is over there, but the judgment is a judgment of the court. You cannot overrule a judgment of the court like that. Is that clear? Pranjali. Moving on. So, the Law Commission has given its report on this sedition law. Now, the 22nd Law Commission of India is headed by very, very important former Chief Justice of Karnataka High Court, Justice Rithu-Raj Awasthi. Very, very important. Please note the name, Rithu-Raj Awasthi. Sedition law comes under 124A of the Indian Penal Code. The 42nd report of the Law Commission termed the punishment as very odd. Now, why did it term the punishment very odd? Now, let's see. Let us see what happened, okay? Now, if you see, what is the punishment that is involved? Imprisonment for life. Life imprisonment. Or 7 years. मतलब कोई अगर कुछ बोल दे अगेंस्ट द गवर्नमेंट, उसको लाइफ इंप्रिजनमेंट दे देंगे, डेथ पेनल्टी दे देंगे. इट्स नॉट डेथ पेनल्टी, आई एम सॉरी, बट इट्स लाइफ इंप्रिजनमेंट. पूरा जिंदगी वो जेल के अंदर सड़े. Now, the punishment was given by the Britishers to curb India's freedom struggle. Now, that we cannot do in today's democracy because we have a right to freedom of speech. नहीं तो 90% of the YouTubers will be in jail today. Am I clear, everyone? Is that clear? Is that clear, everyone? Yeah, it will be a contempt of court, Nandita. Absolutely. Yeah. Is that clear? Every one of you, everyone. So guys, if you're liking this session, do press the like button. Do share this session with your friends, okay? All of you, am I clear? Okay? Okay. Moving on. The government, the union government has come up with the government of the NCT Ordinance 2023. This ordinance was brought within a week after a 5-judge constitution bench of the Supreme Court held that the Delhi government, the Supreme Court, a constitution bench of the Supreme Court held that the Delhi government has power over services. Now, what is services? That means the Delhi government will have the power to appoint, to post within the services. कौन चीफ सेक्रेटरी होगा, कौन प्रिंसिपल सेक्रेटरी होगा, कौन सेक्रेटरी होगा एजुकेशन डिपार्टमेंट का, कौन सेक्रेटरी होगा इस डिपार्टमेंट का. Who will have the power to appoint and transfer? So appointment and transfer was with the Delhi government. That is what the 5-judge bench of the Supreme Court said. The Supreme Court said that the Delhi government will have the power of appointment and transfer insofar as services are concerned. Now, with this ordinance of 2023, the NCT, the government of NCT Ordinance 2023, the central government has overturned the Supreme Court verdict. Now, how? Now, Article 239AA subclause 6 requires that the elected government be vested with control over official posted in its domain. So, the state government, देखिए, West Bengal government डिसाइड करेगा कौन चीफ सेक्रेटरी बनेगा, कौन प्रिंसिपल सेक्रेटरी बनेगा, कौन ये बनेगा, कौन सेक्रेटरी इस डिपार्टमेंट का, कौन सेक्रेटरी बनेगा उस डिपार्टमेंट का, कौन सेक्रेटरी बनेगा. But Delhi government does not have the power, although Delhi government is elected by the people. Now, here was a huge ruckus, and a 5-judge bench of the Supreme Court said that Delhi government is an elected government. People have elected the government, Kejriwal government. So now, can the union government say that I am taking over the power from the Kejriwal government? Now, this ordinance, what does this ordinance say? I will not explain to you. We will definitely have a session on this later. What does this ordinance say? The ordinance makes a committee. There's a committee, okay? There is a committee which is comprising of the chief minister, and 2 senior bureaucrats who would recommend the lieutenant governor regarding transfer and posting of civil servants. जो IAS IPS ऑफिसर जो लोग होते हैं, IAS ऑफिसर्स जो लोग होते हैं, इन लोगों का ट्रांसफर ऑफ पोस्टिंग किसके ऊपर रहेगा, सेंट्रल गवर्नमेंट या स्टेट गवर्नमेंट. Now it also, this power says that there will be chief minister plus 2 senior bureaucrats, 2 IAS officers, so equals to 3. These 3, so these people, 2 IAS officers are reporting to whom? यूनियन गवर्नमेंट. तो यूनियन गवर्नमेंट जो बोलेगा, सीएम अगर उसके अगेंस्ट में भी बोलता है, 2:1 मेजॉरिटी में जो सेंट्रल गवर्नमेंट बोलेगा वही होगा. However, the LG will have the sole discretion in taking a decision. LG, who is nominated, the lieutenant, see, the governor are appointed, okay, by the president. They are not elected, number one. They are the nominee of the union government in every state. Now, there has been a lot of debate about whether there should be governors in an elected government. What is the use of a governor? Now, governor kya cheez hai? And I'm sure that you must have heard that many incidents of governor, how they have been misused in the past. So, I don't want to get into any debate. But yes, governor's office has been misused in the past. That is what even the Supreme Court has said. Especially in the Shiv Sena case, the Supreme Court said that yes, the governor should not have asked for a voting in the house, in the Uddhav Thackeray and Uddhav Thackeray Shiv Sena and Eknath Shinde Shiv Sena's that split judgment of the Supreme Court. So yes, but you know, the country has a particular way of functioning. Might in the future it might change. Okay. Number 7, Uniform Civil Code. The 22nd Law Commission of India has issued public notice asking people, religious organization to give their views on Uniform Civil Code. Now, what is Uniform Civil Code? Now, Hindus, Muslims, all Buddhists, Parsis, every religion, okay, Christians, they have their own set of rules of marriage, of divorce, of succession. हिंदू लोग शादी कुछ कानून हम लोग का है. इस्लाम जो फॉलो करते हैं उन लोगों का कानून कुछ और है. क्रिश्चियन लोगों का कानून कुछ और है. पारसी लोगों का कानून कुछ और है. Now, Uniform Civil Code says that irrespective of your religion, whether you are a Hindu, whether you are a Muslim, whether you are a Parsi, whether you are a Christian, whichever religion you follow, doesn't matter. There will be same marriage laws. Now, it's a very good thing. I think the country, as well as Dr. B.R. Ambedkar, also suggested that someday in future, all citizens throughout the territory of India will be subjected to the same laws. But you know, there are certain basic problems with this Uniform Civil Code, and I'll tell you that, one or two. Now, there are a lot of places, like in the Northeast, there are tribal people. We have a patriarchal society. शादी के बाद पति का सरनेम लेते हैं लोग. बच्चे जब पैदा होता है डैडी का सरनेम लेते हैं. कुछ ऐसे ट्राइबल एरिया है इन नागालैंड, त्रिपुरा, those areas जहां लोग मैट्रिलिनियल सोसाइटी में है. शादी के बाद लड़का लड़की के घर चले जाते हैं. Now, marriages happen differently. There are places in Kinnaur district in Himachal Pradesh where, you know, one wife will get married to 2 brothers. दोनों भाई के साथ क्यों शादी करते हैं? क्योंकि लैंड कम होता है. जितना और भी होगा और भी और एक फैमिली आ जाएगा तो प्रॉपर्टी डिवाइड हो जाएगा. So it's an old way of thinking. Now I'm not saying that something is good or something is bad, but the government will have to also tackle all these things. The government will also have to tackle all these things, right? So yes, it's a great initiative by the government, but how far will it be able to tackle all these problems across India? Because India is a diverse country. शादी का बहुत कानून होता है, ठीक है, कुछ कुछ जगह दूसरा दूसरा कानून भी होता है. So we have to understand that, right? So I hope I've made myself clear. Yes, another very important reminder, guys. BYJU'S Exam Prep brings to you a 6-hour non-stop marathon happening on 29th of July 2023 at 11 a.m. Do not miss it. BYJU'S Exam Prep also brings to you a free live interactive workshop happening on 30th of July at 6 p.m. Accelerate CLAT Success, Conquering the Exam in 5 months by Nivedita Raji. BYJU'S Exam Prep brings to you a comprehensive course wherein we are going to provide you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of CLAT question paper. So guys, do like this session, do subscribe to our YouTube channel if you haven't by now, do follow us on our Instagram, like our Facebook page, join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app today. Thank you very much. God bless you. So give your likes and do subscribe to our YouTube channel. Bye-bye. Take care. Have a great day ahead. Thank you.